Good afternoon, everyone, and thank you for joining us today for this rules workshop. I am Amelia Boyd, and I'm the program manager for the Commission. Jimmy Bush and I are the organizers for this webinar. This meeting is being recorded and will be made available sometime next week. The documents which will be discussed here today are available in the handout section and on our website, which is wmc.wa.gov. All attendees are muted. Panelists may unmute themselves and share their webcam. Attendees, if you have a question, please use the raise your hand function or use the question section, and we will get to your questions as quickly as possible. Please refer to the agenda for the topics to be discussed, and I will begin the roll call of panelists and staff. When I call your name, please introduce yourself. So we will start with Dr. Roberts. Go ahead. Oh, you're muted.
I'm Dr. Alden Roberts. My background is in general surgery, and I've been on the commission for a long time.
Heather.
Sorry, yeah. Heather Carter, Assistant Attorney General, Legal Advisor to the Commission.
And then Jimmy Bush. Maybe not. Melanie, go ahead.
I'm Melanie DeLeon. I'm the Executive Director of the Medical Commission.
Micah.
Micah Matthews. I'm the Deputy Executive Director of the Commission.
Mike Farrell.
I'm Michael Farrell. I'm the Policy Development Manager for the Medical Commission.
And Yan Lane.
Yan Yu, public member on the commission.
And then Christine, if you will introduce yourself and read the script for us, please.
Alrighty, Christine Blake, public member of the commission. I will be the presiding officer for this rules workshop. Today is Thursday, June 17th, 2021, and it is 2:09 p.m. This meeting is being held via the GoToWebinar platform and will end at approximately 4 p.m. The rule being discussed today is regarding stem cells. The pre-proposal rules package was filed in Washington State Register as 2009132 on April 21st, 2020. Amelia, please give an overview of the rule process.
So first we'll talk about what is a rule. A rule or regulation is a written requirement that applies broadly across a group of individuals or entities that enables, guides, or directs them to do something or prohibits them from doing something. Specifically, a rule establishes or subjects individuals or entities to penalties if it is violated, or is a qualification or requirement that gives a benefit or privilege, or sets qualifications or standards that an individual or entity must meet to get a license or permit, or sets standards that must be met before a product or material can be sold. So why create this rule? The Commission has received complaints from licensees, stakeholders, and the public about the use of stem cells. The complaints have been regarding the advertising related to stem cell therapy, practitioners using non-FDA approved stem cell therapy, as well as concerns stem cell therapy not being within a practitioner's scope of practice. Regulating the use of stem cell therapy would place the Commission in an active patient safety role. Rulemaking would provide clarity around this emerging medical technology and procedure to help avoid potential discipline and increase patient safety. The new sections being considered will potentially benefit the public's health by ensuring participating providers are informed and regulated by current national industry and best practice standards. Back to you, Christine.
Alrighty, if there are any questions about the rule process, please input them into the questions section. The next item on the agenda is to discuss the draft language.
So the draft language is in the packet, which is also in the handout section and should be on your screen. So this has been out for about a week, and so the panel can just discuss what we have here, and then if we have any questions from the audience, we will talk about those as well. There's no questions at this time.
I have a question, if I may.
Sure, go ahead.
The language, let's see, I need to get my screen, get my stuff up. The language first said, if it's number one, the physician shall now not prescribe, administer, or dispense stem cells or any form of stem cell therapy that's not has been first approved by human use. So my question is, by the FDA. So my question is, this only apply to that has been approved by FDA, right? So if it's not approved for any use or even off-label use, it cannot be prescribed. Is that correct? The reason
That's how I would read this.
The reason I'm thinking about this because in the RCW just passed, I can't get my own screen up. I'll try to get a smaller screen, get my own screen. There's RCW 18-130-420, stem cell therapies informed consent, and in that particular RCW, it basically said if you prescribe stem cell therapy, you have to inform patient whether it's informed by the FDA or not. Must be provided under the Washington law, the informed consent. So my question, that's what my question comes from, that this in this draft language, informed consent does not, the situation will not rise to informed consent, right?
So
I'm gonna
this
push-
is Heather. Maybe I can help a little bit. So the RCW, which is applies to all health professions that can perform this sort of service. So MDs, PAs, DOs, there may be some others. So it says that if they're going to perform stem cell therapy that is not FDA approved, you have to provide a certain notice, and it gives you the actual language in the notice. You have to get informed consent, which it specifies, and then it also provides restrictions on advertising. So
Right.
that was passed by the legislature, I think, in 2018.
Right. But this one does not apply that, or that particularly RCW will not apply to this rule, right? Because this one, it has to, whatever you provide stem cell therapy, it has to be approved by FDA. If not approved, if you prescribe it, it will be unprofessional conduct. Is that correct?
Right, and that's what subsection 1 it would appear to try and ban the use if it's not FDA approved. And I do think that that is probably inconsistent with the statute, which allows it under certain circumstances.
Right, that's what I'm a little confused about it. And then what if there's a FDA approved a certain use and then someone use off label? Would that be considered under this particular rule?
And Ling, obviously don't have the answer to your question. It sounds like this rule is more restrictive than the law, and what Heather is saying is that we may not be able to apply the rule because it is more restrictive than the law. I would question about the way our wording is. Do we have a mechanism that would allow for research?
So the statute, which is in the UDA, does have a exclusion for investigational, license holder who has approval for an investigational new drug or device. There's also some other exceptions in there.
Well,
Down in, if you scroll down, Amelia, it's in section 5 of the statute. And I think your proposed rule also has some exceptions for those same things.
good.
So I didn't really look at the exceptions. Are they consistent with the statute then passed in 2018? You know, Heather?
Yeah, the exceptions I think that are written in your proposed rule a little bit further down, I think in section 3, mirror what's in the statute for the investigational drugs and devices. My concern was just with section 1 of the proposed rule and the inconsistency with the statute.
So one of the problems with what we have been asked to look at in the past as it relates to stem cells is that it's currently being used without any guidelines at all, and it can be used for anything, and it's not being studied, and it's just a really, I think, it's not a fair way to practice as it relates to your patients, because you can't do an informed consent because you don't know what's going to happen. And or you don't, not only do you not know what, it's never been used for this before, and you're outside of a research study, and so using things where you're just sort of making up what the use is going to be isn't something that as a commission we condone. Question is, how can we phrase what we need to phrase to be consistent with the law and to require responsibility on the part of people who are using this, and require a responsibility that is sort of standard across how we do things.
I actually agree with you, Dr. Roberts. I like this stem cell language, and I think if it's not FDA approved therapy, that should not be prescribed or recommended. It just, if someone recommended a therapy was not FDA approved, then it seems like they were subject to the commission sanction rule. But they can argue under RCW and say, it said you seems like it imply you could if you provide informed consent. So in that situation, who is take a precedence, or who is taking, what do you say in the legal language? You know what I mean, Heather?
Yeah, so if a rule, so the sort of hierarchy is the statute, so the RCW, then the rule. So the statute will trump a rule, and rules that are inconsistent that a court would find inconsistent can be declared invalid.
Okay.
One option that I thought, you could have I think the record keeping requirements are a good thing or don't conflict with the rule or with the statute. And to kind of along the lines of what Dr. Roberts was saying, if you wanted to do some sort of policy that talked about, risks and efficacy and how you're going to evaluate a complaint, that could be helpful. It's not enforceable on its own, but if you had a case with stem cells, you could use that as some convincing evidence and something to gauge the complaint off of. That's just one idea.
So Heather, I'm going to ask you, I guess point blank, is the language under paragraph 1, we can't include that because it conflicts with the statute?
Yeah, in my opinion, it's inconsistent with the statute. The statute allows you to do the non-FDA as long as you provide X, Y, and Z. And I think, that's what the legislature has said. I think there are other, you could put other parameters about the use of stem cells that you might want to incorporate into a rule, but the outright ban, I think, is problematic.
So Heather, I just want to, because we're on the record here, I want to be clear. If the legislature had not, in fact, passed the 2018, for lack of a better term, definition of how to do stem cells and make it very difficult about advertising, we would have the freedom to ban the practice, correct?
Likely we'd have to look at, we still have to look at your general rulemaking authority. And when you're getting something specific like that, you want to have more specific authority. This would have, if you were without this, you would have to go under your general rulemaking authority, and we could sort of evaluate whether or not that's in or outside your authority. But it's, yeah, arguably you could.
Thank you.
Can we make draft language or include language that would say that, I don't know, it's not recommendation, but it say we, the first line of standard care is to approved by FDA, but if indicated by the medical condition, by the patient's condition, you can use it, but informed consent have to follow based on, follow the RCW. Is there anything on that? Then you can evaluate risk and benefit, and then you leave a door open for consistency with the RCW passed 2018.
When we're talking about adding parameters, could we add a parameter such as if you're going to use off-label, it either needs to be in a research study or be approved by a sort of a blanking on the name, but well, never mind.
Like an IRB or something?
You're not
IRB
thinking of an IRB, are you?
Yeah, something similar to an
Investigational
IRB.
Review Board? Yeah.
Yeah, something similar to an IRB.
Well, off-label is different. If my understanding is off-label is different from the for approved research study or something under investigation purposes, because that proved that would be they follow strict rule, informed consent, whatever the procedures, but off-label can be very loose. So they typically, in my understanding, they governed by very different rules.
And I agree with you, Yan-Ling, but we can't outright ban. Heather does not think we can outright ban this. And so if we could add something to the effect of having an IRB if you're going to be using it off-label.
And Alden, are you also thinking about an independent ethical review board or research ethics board, or
Yeah,
just IRB?
Pretty much an independent ethics board. Something which actually provides patient protection.
Because there's also the research ethics board and the ethical review board, as well as the IRB.
Any mechanism that we would have to assure that patients are being adequately, or that the study that is being, or what is being used for, is something which doesn't put people in excessive risk.
Yeah. Well, if we change the language in section 1, I don't know. I'm still confused to how we reconcile the conflicts between the language drafting item 1 and the RCW. If we can find some way, but I think if we loosened up, I think informed consent is very important in there.
Well, I think, yes, Yanling, informed consent is, but by itself, that doesn't really protect anybody from much. And often the way it's done is not particularly thorough. And so, yes, it is important, but it also would be worthwhile to have an independent, Christine, I'm just going to use your ethics term and just say an independent ethics or IRB type committee to look at what's being done and assure that it is a reasonable approach. But what you don't want is for big promises to be made and they're based on, oh, I had this patient once that this happened when I did this, because that gives false hopes and it's not an appropriate mechanism for how to manage this.
Well, where is this IRB going to be? Is it under commission or is it some?
Us.
Pardon me?
It can't be us.
Okay, it's someone else. So the commission, yeah, I'm just trying to understand the process. So the commission, if someone, let's say someone filed a complaint and said, this stem cell provide to me and there's not FDA approved and then it's not under a research project and it's used off label. So how do we, the commission will seek out an evaluation from the IRB or what is?
No, it would be required prior to using it for that particular diagnosis or whatever. And I don't know that we've ever done anything like that before. I don't know whether that's feasible or not. It's a unique situation. There is a similar situation which happens with Botox, but Botox has been rather extensively studied, and the uses for it are evolving still at a fairly rapid rate.
Okay. Well, if it goes to IRB, just the case is still under jurisdiction of the RCW about a stem cell.
I don't know that we
can still cover it.
I don't know that we could add that or not because that's not a part of the law. I mean, they've prescribed, what's been prescribed. I'm not sure that we can alter, can we, Heather?
So I guess I'm trying to figure out if the IRB is something different than is what in the statute in 5A and B. I'm not familiar with really what the IRB is, or if that's sort of what A and B are talking about.
No, A is the FDA, which is different.
Okay.
It's not listed in there at all.
Okay.
No.
Okay.
So we do have a few comments from the audience if you'd like me to share those right now.
Sure.
So the first one is off-label means the use of an approved product for a reason other than what the drug was approved for. So if the product is unapproved, it can't be used off-label. So that's the first comment. Then there's a question, is there a way to add something to the draft rule that would allow for off-label use with patient consent and understanding of risks?
That's what the RCW is. Basically, it's not approved by FDA, then you need to have a consent from patient.
And then we have, this is the last comment for right now. It says, I think you are well within your authority to outright ban, quote, unapproved stem cell therapies, assuming they require approval in the first place. But many stem cell therapies are exempt from approval, and that's where these additional patient protection mechanisms are appropriate.
Well, I am all for it if there's no conflicts, if it's no, if it's some way can doesn't create conflicts with the statute, I think, a strict rule on the safety of stem cell would provide the best protection for the public.
I think Heather might need to address that last comment, or at least clarify the passivity, the passive approval of the law versus what we're trying to do as an active prohibition.
Yeah, so I think you're right, Micah, that the RCW that was passed by the legislature contemplates that people can legally use these stem cells for purposes not approved by the FDA, as long as they, kind of do these 3 things that are outlined in the statute. And the statute is going to trump a rule. And I'm curious what that one of the commenters said that these could be exempt from approval. I guess I don't understand what that means. Or if all of these things need to be approved, or if some just have never been approved because they don't need to be approved. Or, I think there's a mix of all sorts of things going on.
So that was Andrew's comment. Andrew, would you like to speak to that? I can unmute you. Maybe not. We do have another hand raised, however. But I don't know how to. So Melvin has his hand raised, but I have no way to unmute him for some reason.
Can you hear me?
Yes, we can. Thank you.
I was just going to suggest, perhaps this is my naivety, but can you not ask the Attorney General for some help on how to phrase this so that this stem cell problem can be better attacked? Because it's, it's quackery, and we should, as a commission, not be allowing this sort of thing to happen if we can do something about it. And it's very frustrating to hear that you're hamstrung by RCWs that have vague language. So couldn't Bob Ferguson help you? I don't know.
And Andrew, I would agree with your comment. On the other hand, we are stuck with abiding by the laws, which is probably a good thing. I think Heather has a pretty decent handle on what we can and can't do. The question is there a way around it? And that may require more attention.
Can we say this rule only apply to FDA approved stem cell? And can we make that?
I don't think that does anything, because that means anything that's not being done that's not approved or not been investigated isn't governed by the rule. And that's what we're actually trying to govern, stuff that shouldn't be done.
So just a comment. I think, looking at what statute was passed in 2018, the base intent was to make it onerous to do this when it's not FDA approved. I think that is kind of the restriction that we have now in this rule. If outright prohibition is not available to you, I think that creating some standards that keep things in place for patient safety purposes, but also some documentation and accountability might be the way you can go. I think no matter what you do, you're going to have to strike one. I even identified that in not being a lawyer. However, I think that I'd like to pursue maybe a little bit of discussion around Dr. Roberts. You made a comment saying it's something to the effect of it's impossible to do informed consent on this because you don't know what's going to happen. And informed consent being a pretty established process and understanding, I wonder if maybe there's an opportunity there to discuss a solution that might be applied to this.
So unfortunately, my comment is poorly worded, as you reflected in your statement there. I think the problem that I have is that informed consent doesn't mean that you can give Laetrile for cancer. And that's what we're running into here. And I'm not sure. I recognize that an outright prohibition is probably not going to fly and maybe shouldn't fly. But there needs to be guardrails, and I'm not sure how much leeway we have to put those in place.
Maybe we start with the concept of the guardrails and say, okay, for an experimental, non-FDA approved use, and I apologize for the coughing toddler in the background. What would your ideal set of guardrails be? And then just list those out, and then you can whittle down based off of what the law allows you to do.
So ideally, if it's going to be used for a non-FDA approved issue, I would like it to go through an independent IRB equivalent. It can be a hospital IRB, it can be a university IRB, any of a variety of things. I still don't like the idea that something which is currently under investigation, well, and efficacy hasn't been proved, and efficacy hasn't even been used for this before. Why decide to use it for that? So I think, again, I guess the first thing would be to say an independent organization outside of whoever it is. You can't just say, I'm going to treat something because I want to treat it. How do we restrict that?
Well,
Okay.
it definitely is. It will be interesting. I don't know much of IRB, but I would like to learn more about how this would that their decisions say this would be good to use or not be good use, or would be trumped by the RCW or whatever. But come back to informed consent. Informed consent does not necessarily to say the physician have to say, I know the risk, I know what the benefit. It's not all about this. It's even if that the drug has not been approved by FDA, there are articles written about it, off-label, of that they actually carry additional risk. They have in JAMA or JBM, what is this article? General Medical article. They talk about the additional risk, and they have a statistical study that non-FDA approved drug actually carry higher risk than FDA approved drug. So statistically, they carry uncertainty is type of risk. So I think informed consent is still important. It doesn't necessarily say this would be definitely improve patient safety or save patient from harm, but it does focus on patient-centered care and give the patient to the opportunity to participate in the decision making, so they can join make decision whether they go forward or not go forward. So I think it's still very important piece of guidance that the commission should consider.
So Yanling, let me ask you this. If you have a medication that there've been 30 studies out on it, it absolutely shows no evidence of efficacy. And I go to you and say, I think you should try this medication. It might work. The risks of the medication are you might faint or you might have high blood pressure, but I think you should try it. Now, is that informed consent? I didn't tell you that there are no studies that say that it works. So, you know, and again, I'm going to go back to the issue that we had 30 years ago with Laetrile. We had people out there using this medication, which was clearly not effective, and people were choosing that because they're being sold snake oil over legitimate treatments. So significant harm was occurring. And that's what I want to avoid here.
Right. Informed consent means you laid out what has been known, what not known, and what alternatives that gave the option for a patient to jointly make decision together. And like you said, if in a situation in the past, it had been many studies shows this is have a loss of a risk and harm have been done. And then the provider say, I recommend to you, then that become a risk benefit again. And that shows more risk than the one single, maybe a little bit of benefit. So that really is a decision-making process that
So,
can
all that an informed consent requires is that you explain risks, benefits, and alternatives. It does not require that you explain everything that's known about it.
Right. If you have a 30 studies that shows have been harmful, not useful, that is a risk. May not be particular risk to you.
Number one, you don't have any.
Risk.
Number one, you don't have any studies. There isn't a requirement that says you have to say that you don't have any studies. I think your informed consent is an important concept, and it needs to happen, and it needs to happen with virtually all treatments in one fashion or another. On the other hand, to depend on informed consent to protect a medication whose uses haven't been defined at all isn't going to work. We aren't going to be able to hold. They're going to be able to say, "Yeah, I did informed consent. Here's what I told them."
Well, certainly, informed consent is not your only decision to decide whether that is harm the patient or causation. You have to look at a risk benefit later on, particularly to that particular patient. So you have to look at everything, but in general practice, shared decision making should build into all the, the medical recommendation.
But I think you're confusing what ought to be an informed consent, what we wish is an informed consent, and what an informed consent actually is.
No, I don't think I'm confused. I mean, I have a look at informed consent a lot, and the shared decision making. I think
I agree with the shared decision making, but you're talking about the practice of medicine in which we have benefits and alternatives that we know will work in one fashion or another. Some are better than others, but I may choose one because it's better for me, and it's better for me because I don't want to put up with the side effects. But we're talking about something where, we're talking about, I had a patient yesterday that this worked on, and so I think you ought to try it. And that really isn't protected by either shared decision making or informed consent. I just don't think there are ways around what you're talking about. It's too easy.
I think you're talking about protection. I think you and I maybe talk about slightly different focus. I'm more talking about a process, because informed consent is process.
So this is Heather. I will say that this stem cell therapy statute does provide for a certain consent form to be signed by the patient and has some requirements. I think it is reasonable if the commission wanted to sort of clarify more what you really want in that form, and if there are specific statements you want made in a form about stem cell therapy, I think you could require that. You could put that into rule and clarify what is anticipated results and what are possible alternatives. You could define that and say exactly what you want in that form. So if you wanted to beef up for just stem cells, this would be just the stem cell non-FDA approved form. I think you could do that. That's just, I think.
I'm not.
Heather?
Go ahead, Micah.
So on subsection 1, just to try and address the IRB side of things, would we be within our legal limits to say a physician shall not prescribe, administer, or dispense stem cells or any other form of stem cell therapy that has not been approved by the FDA without and this is the language that gets a little loose here, without going through an IRB, or an independent IRB?
I don't know. I couldn't tell you off the
It's
top
not
of my head.
banning it, but it's adding a condition.
Yeah, I think I need to have a better understanding of what the IRB is, because I really don't. And that's something I can look at. I don't know off the top of my head, or can't make that judgment right this second.
Sure. The other thing that I would caution is that I don't think forms are a very good mechanism for getting people to understand what's going on. Christine, you wanted to say something?
Fair enough.
The International Society for Stem Cell Research has a standard of informed consent on their website, if you wanted to look at that, Yenling. And there is some language in there that, might be of interest to you, but I think, and being in a hospital setting and Dr. Roberts being, surgeon, and the informed consent that you give to a patient is, you can't cover every little detail. The patient understands what they're going, why they're there, the risks, the benefits, the alternatives of the procedure that they are agreeing to have, which would be basically the same thing if you're agreeing to be a participant in stem cell research. You're never going to be able to cover every tiny little thing. But you're going to hit the highlights of what, if known, that could occur.
And I would go back to saying every surgical consent that I have ever used, I don't know that a patient has ever read that consent from top to bottom.
Exactly.
And I don't think forms are going to fix the problem.
No, it's not. There's always a way around a form that you sign.
Well, informed consent, I can't tell you how many people they have informed consent read before they roll in the surgery room, and you sign this. Of course, it's basically you read about here's this. The list is the risk is mile long, and you sign it and you roll in the surgery. That's, as I said, informed consent is a process. It's to help patient to to understand. We don't know everything. Like Christine said, I don't think anybody expect the doctor know everything, or even the best doctor, best researcher know everything. But whatever we know, that is what we know. What is the risk and benefit? What is uncertainties, and what is the alternative? So that is what reasonable patient would know or want to know, and have a process or discussion rather than say, here's the paper, signed up, and that's not it. So yeah, right. I agree with some of them say.
So I agree. An informed consent happens in the office. It doesn't happen on a piece of paper.
There are lots of papers written about professional standard for informed consent for stem cell therapy, and there are papers written about it. A recent paper, 2019. Informed consent, federal funding for stem cell research. Sounds of it. But I got the impression from you, Heather, that is, we cannot have the current draft language, number one, right? Is in conflicts with the statute. We have to do something, right? That's the conclusion we got.
Right. I think the sort of outright ban would be in conflict with the statute. That's, yeah.
Okay. So the next question is how we can get around it, not totally ban this type of language to provide the best protection to the public, right?
Right.
And that was the source of my suggested edit of don't ban it, but add a pretty strong condition that you won't operate outside of something like an IRB or the number of other things that Ms. Blake or Dr. Roberts mentioned.
Well, if you have if IRB can work into a rule that can apply for the commission, does the statute can still apply, or the statute will not be in the picture anymore?
The statute it will still apply. I mean, the statute, so anytime so depending on where we land, you know, someone doing this is still going to have to comply with the notice requirement, the informed consent, and the advertising portions.
I mean, I drive a car, I heard advertise the stem cell, it cure all kind of problem. It really makes me wonder this type of advertising, how much could be misleading to patients.
That would be most of it.
Yeah.
Well, can you use stem cells on your car? Because that might be helpful. Mine's getting kind of old.
It's usually a gasoline additive.
Cell fuel. Isn't that cell? Fuel cell. No, fuel cell. I'm sorry. Backwards.
So we do have a few more comments. I'm going to put them up on the screen. And I will also read them. This says paragraph 1 makes an assumption that the FDA has and should have complete oversight over the use of all use of stem cells when in fact this is still being discussed and formally challenged, particularly in the case where it is a clinical surgical procedure completed in a single procedure. In the practice of medicine, the involvement of stem cells is ubiquitous in the full range of medical procedures such that these tissues/cells are not a drug or medical device, so does not require FDA approval. And then comment 3 is actually from the same person, so we'll jump to it real quick. Homeopathy is outside the purview of the FDA, yet they aren't required to even provide an informed consent, let alone any clinical study standard. While some may think all homeopathy is bad, others think all homeopathy is good, and the reality is closer to a combination of both good and bad. Stem cells as a practice of medicine is outside the oversight of the FDA also, and would be inappropriate to try to impose rules on the practice of medicine by non-medical entities. Does anyone want to comment on those comments?
Well, relating to 3, while homeopathy and alternative medicine in general, I'm not sure if they're entirely outside of the FDA purview. Just with respect to our laws, there is a specific exemption that the medical commission won't take action purely because someone is practicing alternative medicine. Usually what happens in those cases is they are performing treatments that are not efficacious at all, and a patient outcome occurs that is harmful, and that's what generates the complaint and moves the commission to action. The magnitude of harm, I'm not sure I can summarize what the magnitude of harm is, but it's certainly we certainly have received feedback from stakeholders and others with respect to, the seminars where you go and you pay to attend, you pay $6,000 cash to get stem cells injected into your knee and nothing happens. There have been several news stories about that. I can't quantify exactly the actual harms that have occurred, but the feedback that we've received in the public process certainly has indicated that there's a problem, there's a concern, at the very least, with misleading the public. And as this informed consent discussion has demonstrated, the lack of knowns with respect to getting this treatment is a strong concern. If you're trying to recommend to someone that this is what they should have, and there's not a body of evidence that supports what you're trying to do, that raises a concern to the commission level for sure.
I think the first question is relatively accurate. There's nothing in there that I can see that isn't as said in the paragraph.
We do have someone with their hand raised, so I will go ahead and unmute you. Go ahead, Dawn.
Hi, I contributed these questions, and in retrospect, see that they may not be completely clear as to the intent of the question, but I just want to make a comment that it's easy to be upset with the advertising, and I believe I would agree with that, but then that's just my perspective. And I do think it is important that people show that they've been harmed. There's plenty of things that physicians do and surgeons do that are quote unquote FDA approved, or if they're outside the purview of the FDA, or clinically approved by their overseeing boards of certifications in the practice of medicine, licensures that subject people to harm. There's, I would argue that if you add up all of the real harm, other than financial, which is important as well, that the routine allopathic treatments and therapies that are sometimes over encouraged or not can in themselves create a lot of true medical harm. And nevertheless, they fall within the boundaries of the standard of care. And this is definitely an evolving technology and profession that is being defined very rapidly on an ongoing basis. And it has been intently studied with and without IRBs by people all around the globe, and even collaboratively internationally with, I know IRB studies and outside IRB studies. Once again, let's first decide if our actions are to protect the public. Is it simply advertising protection? If there aren't that many actual health harms created, if we are too quick to act too early in the development of this specialty, then it can stifle progress for our public that can be more harmful. Remember, Galileo was put in prison for his adverse thinking. The whole last year, we've seen this batch of studies used to weaponize somebody else's batch of studies. They're all studies. They're all by legitimate entities, yet there's not a consensus. And I think stem cells is certainly in its infancy, and it's not going anywhere, since stem cells are in all of our body. And we have to be careful we don't open up Pandora's box. We look at this with a narrow view and say, oh, we're just talking about this one simple little thing, the stem cell. Well, our bodies don't exist without stem cells. Any part of our body doesn't exist without stem cells. We'd be dead from the get-go because the stem cells keep us alive. And again, let's say, what are the harms that are being done? And I suspect that there is a lot of financial harm and disappointment and misleading by adverse advertising. And I agree with you. I think that that's important. And I believe the statute has addressed that foremost. I'm not quite sure that there is a problem that needs a fix of the type of extremism as paragraph 1. And that is actually being dealt with in a formal fashion right now. So we're kind of putting the cart before the horse if we jump into this the way this is proposed, in my opinion. Thank you for considering my questions.
Does anyone want to comment on that? So, Andrew,
the
are
only
you able...
comment that I'll make on that is, while I respect what the commenter said, the statute that governs the commission deals not only with actual harm but risk of harm, and so that is something they do have to consider when they conduct the rulemaking and their discipline.
Thank you, Micah. So, Andrew, I've unmuted you if you're able to speak. It says you are self-muted. No. He asked me in the questions if I can see his phone. I cannot see your phone, Andrew. Sorry.
Okay.
Oh. So you'll probably need to mute your computer, though.
Can you hear me now?
Mm-hmm.
Great. So again, my name's Andrew Ittleman. I do a fair amount of work in this space. I'm a lawyer, actually. I represent a couple of lawyers in Washington State who use relevant procedures, as well as a company called Regenex, which has licensees in Washington State. And I can see why you're struggling. It makes sense given the nature of the statute that you have in front of you. I don't know the extent to which you all have authority to interpret the statute, but I think that in interpreting the statute, I don't think you would be required, and again, I don't know what the rules are that you have as far as the statutory interpretation is concerned, but I don't see why you would need to read or take an absurd sort of conclusion away from what the legislature has written, because the problem here is that if there's a product on the market that requires FDA approval and it doesn't have that approval, then under federal law, that's an adulterated and misbranded drug. So under federal law, the manufacturer can't distribute it, and the clinician really doesn't have the same level of authority to use it as he would, let's say, off-label if there was an approval and he was using it and the doctor was using it for something other than the approval. But now we're talking about drug products that are prohibited under federal law, and now you all seem to be stuck with the process of, well, how do we get those adulterated, misbranded drug products into the hands of doctors in Washington State so that they can be administered to patients? I think that's an impossible assignment for you unless there was something that was explicit in the statute that said that that's what they wanted you to do. For instance, with the cannabis legislation, there would be language in there that where the legislature is clearly saying that we are diverting here from federal law. We are going our own way here. I don't see that in this statute. And I think it would be perfectly reasonable for you to look at this statute and say that when we're talking about the quote unapproved stem cell therapies, what the legislature meant was that the stem cell therapies that don't have FDA approval, but that doctors can still lawfully use without having that FDA approval, because they're exempt from approval and therefore they're not adulterated and misbranded. But again, when there are products out there, let's say allogeneic products, the quote unquote stem cell products that come in a bottle that are derived from birth tissue, that may be manufactured all the way across the country and then sent to a doctor in Washington, and by the time it gets there, it doesn't have any stem cells in it at all. I don't see why you all should have the burden of creating rules to authorize the use of those products when, again, they're prohibited under federal law, and the FDA's authority on those points is really clear. But there are other procedures that, quote unquote, stem cell procedures that doctors can do without having FDA approval because they've been exempt in one way or another. And further down in the draft language that you have, you actually picked up on one of those exemptions. So we go down a few sections and we talk about the same surgical procedure exemption, right? The same surgical procedure exemption would apply to certain procedures that are stem cell procedures under your statute, but that don't require FDA approval because those are regulated at the practice of medicine, as the practice of medicine. And it's those kinds of medical practices where you should be focusing your attention, saying, okay, these are exempt from FDA approval, but if they're exempt from FDA approval, who's regulating them? Who's overseeing them? That's exactly what your job should be. I don't believe that FDA would expect you to be regulating adulterated, misbranded drug products. And I don't think that was the intent of the legislature here either. It seems to me that their intent was, okay, there are medical procedures that are out there that don't require FDA approval, but we want doctors to be able to use them responsibly. Now we want the medical board to step in and set those standards. And I think you guys are well equipped to do that. That's what I see.
Any comments? So I think our biggest issue right now is section 1, whether to include it, revise it.
I would recommend that we not include it. I think Heather's correct in saying that if we tried to enforce it, it would be overturned.
Okay, hold on. We have one more hand raised. Dawn, if you would like to go ahead.
Yes, I appreciate the last comments that were made, and I agree with the pervasive oversight, control, and enforcement of the FDA that we all rely on. But that doesn't in itself lead to the opposite conclusion of jurisdiction over things that aren't covered by the FDA. So the FDA has been excluded by agreement from the beginning not to be able to have any oversight over homeopathic products. And I failed to identify that when I mentioned my comments about homeopathy. So be it good or be it bad, they're out of the picture on that. And if you wanted to take on the role of a quasi-FDA over homeopathic products, just because they're not enjoying the oversight of the FDA, then that's a pretty big job. And, you know, I guess you can jump in and do it if the legal precedent is there. But the same could be said true of all of medicine, because medicine is not a drug or a device. And plenty of things are being done on a daily basis that advance the frontiers of the practice of medicine as it evolves. And some things are recapitulated and brought back into favor with a little twist of this or that. And if every single decision had to be approved by your committee, how would you sleep at night about whether you made the right choice? I mean, the people involved in stem cell clinical research, and I'm talking specifically about autologous cells, which are your own cells. This is the whole essence of what we do in medicine and surgery. We were dealing with a patient in their own body, which is a compilation of cells. And this is something that deserves solid science investigation and has discovered amazing findings, but not necessarily so surprising. The body itself is amazing and surprising. And a lot of that is due to the benefits of stem cells. So if something falls under the design of a drug or device, and it truly is a drug or device, then I guess the FDA has purview. The real question, which is under the microscope now, is what is substantial manipulation, and how does that fit when you want to narrow your focus on a stem cell compared to all of the manipulations of tissues and cells that we have done from the time beginning and continue to do every day, because that is what happens in the practice of medicine. Some of the questions raised amongst the panel here about what is an IRB, what is this and that. I mean, we're far downstream from those sort of questions. And I think we got a lot of homework to do before we start creating very restrictive rules and laws on whoever clamors the loudest. Like I say, Galileo was put in prison for his terrible predictions about the world, and other people have been killed and murdered for suggesting sanitation made a difference because it wasn't very popular. Well, you know, as time went on, it proved to be right, and we're learning that lesson over and over again every year. So it's I would beg the committee to give some deep thought to what role you really think that needs to be taken, particularly if there aren't more examples of harm, real physical harm, than what's already being incurred by the standards of care of allopathic medicine, homeopathic medicine that are acceptable. If you look closely, I think you will find that legitimate, well thought out, medically mediated interventions with so-called stem cell therapies have very, very little adverse outcomes. And when I asked for a list of these problems, I've not heard a thing other than misrepresentation in advertising. And I can see that advertising has takes a lot of liberties in every business, and the only written rule they have is buyer beware. So I think advertising deserves to have some oversight, and we've received it. But the practice of medicine is quite complicated, and every day thousands of articles are written from not only the United States but around the world, pushing the frontiers. You can't write laws fast enough to keep up with them. And the better question is, do you need to? Thank you.
Thank you. Any comments? So my question to the panel is, what would you like to do moving forward then? Right, Dr. Roberts suggested removing section 1. How do the rest of you feel about removing section 1?
Based on all of our discussion this afternoon, I would agree with removing it.
Dr. Yu?
Well, it seems like we have no other way around right now except removing it, unless we have like Micah suggests, some type of language in there to get us a wiggle room to get around the RCW. If we remove section 1 in section 2, I would like to see include mention RCW 18-134-20 as a guidance for standard care, recommended standard care.
I'm just making sure we didn't already reference it.
Yeah, I didn't see it because we want to be consistent with the law also. So if we broader our scope that restrict ourselves only to approved stem cell therapy, then there would be non-approved off-label, all sort of things can be prescribed, but then we ought to be consistent with that in, 18-130-42, 420.
So Christine and Dr. Roberts, what are your thoughts about adding language about 18-130-420?
Does it help us in any way? I'm not averse to adding it because that's the basis for what we're going for anything that we can do here. But it already exists, and so if we were to, we could utilize that as a mechanism for investigation. I don't know that it allows us much of a
But
mechanism
I'm
looking.
sorry. If we don't explicitly mention 18-134-420, but I strongly recommend we do include informed consent process in along with the documentation of prescribing rationale, in the records. I think we should, if it's not FDA approved, and certainly physician has discretion to prescribe, medicine, anything, drugs. So including informed consent would provide a active participation from patients to discuss this type of a therapy. I just sent the article to everyone about a JAMA article from 2019. Recommend stem cell informed consent, what should be in it and why it is good. Need to recommend to be done. So.
Thanks, Yanling. Yanling, do you think number 2 kind of addresses what you're talking about? The physician shall complete and maintain the records that accurately reflect prescribing, administering, dispensing, shall document diagnosis, basis for the diagnosis, purpose for which stem cells or stem cell therapy is prescribed, administered, or dispensed.
Right, that's the describing documentation process. To me, that does not cover communication.
So what other sentence or something in there would make you feel comfortable? Would including informed consent, including appropriate informed consent? I mean, what?
Yeah.
Do you think someone's actually going to, if they read this, then pull up RCW 18-134-20 and read it?
I don't know. Probably not. Nobody in the office in a 10 minutes, consultation would put out an RCW to read it.
Mm-hmm.
But informed consent, especially in this type of therapy, recommended non-FDA approval, and in particularly we have RCW recommend that. So I think a rule should be consistent. Just say document informed consent, and whatever emphasize on this is a process. As I said, nobody knows all the risk benefit. Best study drug, there is still unknown risk to physicians. So you do best you can of what you know, the existing, what you know. And maybe alternative, even though there's, you have discretion to recommend it, but you should offer alternative if there's a potential risk in there.
What do you think, Alden? Think we should just put in accordance with RCW 18-134-20, or
I
just don't
like
see
it.
people pulling it out.
Right, and I don't like adding things that already exist.
Right.
And this already exists. We have the ability to act based on what's in 18-134-20 as it exists today. We don't need a rule to do that. As for informed consent, I don't think it'll help. I don't think it'll allow us to basically do much of anything. If it's done properly, that's absolutely wonderful thing, and that's how it ought to be done. But the way informed consent on and the way done across the spectrum of how we practice is extraordinarily variable, and I don't think the requirement does protect patients, because it takes a lot of us who would have cut corners and made us not cut corners. On the other hand, I've seen 15-page plastic surgery consents that I'm pretty sure nobody's ever read in their entire career. I'm not even sure the physician has read them.
But this type of recommendation, is really trying to recommend the best practice. I mean, whether they follow or not, that the commission has obligation to say, here is what recommend is the best center, patient-centered care, better communication about risk and benefit, and this is the situation we recommend you. So I really think we should be consistent.
There is value in a policy for that, because that gets the people who are conscientious, good physicians to do a better job. It doesn't really affect the people that we actually would be disciplining, because it's not something that we can act on very easily. It's not something that communication is a difficult thing to act on. And it's really hard in rules to rely on communication as a mechanism for enforcement. It's pretty easy to say, well, I did say that. And it's also easy to come up with extensive documentation that's got nothing to do with what you talked about. So I'm not certain that I'm not certain we have a mechanism beyond 18-130-420 with which to move forward. And that's unfortunate.
Let me get a clarification. Is the rule we're making right now has any enforcement? Can we enforce this? It's not policy. This is can we enforce this for any complaint coming in? Can we use it?
Yes, you can. This is Heather. Yes, you can.
Okay.
If whatever's in rule, you can. That's what makes it a rule, is you can enforce it. So if you got a complaint about inappropriate stem cell therapy, you could charge someone for poor record keeping and not having a proper informed consent, both under the rule and then under the statute as well.
Okay. Okay. Thanks for clarification. Yeah, I mean, if we have a statute in place, then stem cell, especially if the statute is for unapproved, not approved by FDA, then we ought to be consistent with that. As a patient, as a public member, I'm sure the public would welcome to have informed consent built in the process for approved stem cell. And stem cell is new, pretty new right now. And FDA have concerned about, an article I sent to you, the FDA have released a statement about how, recognize the advance in medicine in stem cell, but also recognize it have been used improperly and has caused patient harm. So I think it would be good to include.
So we do have some suggested language from Susan Gregg, who's one of the program managers for one of the other professions. It should be on your screen now. It says a physician prescribing, administering, or dispensing stem cells or any form of stem cell therapy shall provide the patient with informed consent consistent with the requirements in RCW 18.130.420.
Sounds good.
But what are your thoughts about that, Dr. Roberts? You
Why
disappeared
does it
from your
require a
screen.
rule? Why does that require a rule? It's already in 18-130-420.
Mr. Farrell, did you have a comment? Sorry.
We can already enforce that without a rule. We have a law. And where I am right now is I don't see that we have anything that we can come up with as far as a rule is concerned that isn't in 18-130-420, regardless of how much we want to.
Did you have a comment, Mike?
Yeah, it sounds like there's a lot of statements you want to make that really aren't appropriate for a rule. So just a modest suggestion, you raised it earlier, Dr. Roberts, maybe a guideline or a policy that you can go into all these nuances and talk about physicians using stem cell therapy not approved by the FDA are taking a big risk, and you can make just about any statement you want. If you look at the draft rule, there's footnotes, which I don't think can go into a rule, but that information in the footnotes are really important, and that can go into a policy. The Federation has a really nice policy from 2018 that we can borrow from quite liberally, and then add whatever kind of statements you want, including references to the current statute. And then you can think about what's the purpose of a rule. I mean, or what are we trying to do? Provide guidance to prudent practitioners on this emerging area of medicine, or do we want to provide a few mandates that we can use to charge doctors with? If it's the former, let's go with a guideline or policy. If it's the latter, then a rule, or it could be both.
Could it be both? So who rated this rule in general? Who rated it? Is only commission rated, or is also the practitioners also rated?
Yan-Ling, are you talking about policy or a rule?
This rule, who raised it?
So for as far as a rule is concerned, it doesn't make a whole lot of difference whether somebody reads it or not. They're obligated to follow it.
Well, who raised it depends on what the audience. Then you put a language specifically for the audience.
Right.
If for the commission, then the commission is trying to use for both policy and for enforcement, the regulation. But if for physicians, the physician rated probably to guide their practice. So you have slightly different focus. It depends on whose the audience are.
So I'm not sure I follow, Yan-Ling. A rule is a requirement that you need to follow, and if you don't follow it, it doesn't matter whether you read it or not. So it doesn't.
Okay.
So it's a commission thing that says, yes, we can enforce this rule. You didn't follow it. You need to read it now so that you will follow it in the future. And here is your disciplinary action to require that. The
Okay.
policy is different. The policy is what Mike is talking about. And right now, I think that's the only option we have available. I think we can enforce what's in 18-134-20. We don't need anything else. I'm not sure what would fall astray of that, but we might find something that does. And it might pick up egregious issues, which that's certainly a valid thing. What a policy has the potential to do is to help good doctors do better.
All right, but you can't enforce with the policy. So then, so they have to be aware there is a stem cell statute. So that probably good actually mentioned in this rule then.
Well, you don't have to be aware that there's a statute. You just have to follow it. If you don't follow it and we get a complaint, then you get hit upside the head, and now you do have to follow it. And in terms of how do you get people to know what the laws and rules are, you can't. Nobody's going to read all of this.
Okay, so let me ask you a question let me understand. So if you're true, as a practitioner, it is your obligation to understand the law, how to practice medicine. So if we don't put in there, if there's a complaint said, I was not properly informed, I was harmed on this stem cell therapy, can you charge, say, you did not have informed consent with the patient? Can you do that if it's not in the rule? You can't.
Say that again. I'm not sure I understand. Say that again.
Michael and Micah all not there, so you can, right?
Yes.
I didn't understand.
So Mike, I think the question was if someone files a complaint on a practitioner that they did not perform informed consent with a stem cell thing, that's gonna, and Mike can correct it's one of the 27 no-nos. I think it's like sub 7 or something, violation of a state or federal statute.
Okay.
But that doesn't require a new rule. And in addition, that's basically in 18-134-20.
Well, I can go either way. You put in, I don't see any problem to put in remind in the rule repeated RCW 18-134-20, or if it's really is repeated saying they put in a policy, and I guess that's still fine as long as you protect the patient have this options.
So Micah, let me ask you, are we required to make a rule about this?
No, we're not.
I don't see that we have enough to make a rule right now. As I'm looking at what we have in 18-134-20, it says that it restricts what we can and can't do in terms of rulemaking. And I don't see that we can do anything more than what they have in 18-134-20 right now. I don't see the purpose in us making a rule. I really don't see the purpose in us making a rule in which we say you have to have informed consent and you have to read 18-134-20, because both of those already exist.
Yeah. Well, I don't know if Representative Cody have communicated with anyone on the commission. I spoke to her 2 years ago, and the issue brought up on the stem cell informed consent legislature, the bill, and she commented on that the commission still have not made any rule on it. So that's just she mentioned that to me.
Yeah,
so
and I would just follow up with that and say, yes, I have been in communication with her. Excuse me. No. And basically what I would say is we've received the legal guidance with respect to what we can do per the existing 2018 statute. I strongly feel that if this commission wants to go further than what we have on the page, or what we did have on the page, then it's going to require a legislative change, because by enacting 18-134-20, what the legislature did was acknowledge that this could be a treatment that was applied, not give us the leeway to forbid certain uses, but they basically granted authority broadly to use stem cells.
Yeah, I agree, Micah, and that's what I'm not sure I see the function of us going down a rulemaking path with this based on what we have in 18-134-20. And okay.
yeah.
So, I mean, you're a panel, you can vote to recommend rescinding this 101 and doing a policy instead, or a guideline instead.
I would make that recommendation. That'll bring it back to the policy committee and or the rest of the commission. And
Correct,
I think
both.
based on my understanding of what's going on right now, we need more commission input.
Christine, what are your thoughts?
I agree.
What about you, Yanling?
I would like to, if we have more discussion, I would like to hear more distinctions between making a rule and the policy in a form of strikeout number 1. And why not go for the current rule? Why shift to policy? That I haven't fully understand it.
Mike, can you speak to that?
Sure. Right now, if you strike out number 1, what you're left with is documentation, specific documentation. And if that adds value, then if a physician fails to comply with that, we get a complaint, a physician fails to provide proper documentation, you can charge that physician for violating the rule. In the absence of a rule, you can also charge the physician for providing negligent care by failing to provide proper documentation of his or her care of the patient. So you can charge them or offer a STID in either case. A rule makes it slightly easier, so you have to decide whether this rule going through the process adds value. You had a sexual misconduct policy for a very long time. And it's very good and had a lot of recommendations. That's the beauty of a policy. It can have recommendations and advice for licensees, but you could never enforce it. So eventually you came up with a rule with very strict shalls and shall nots in addition to the policy. I mean, you could take that approach. But right now the rule is pretty bare bones. I mean, it's just about documentation.
Don't we require documentation in every other procedure? And why is that a different standard of care? If this is just a doctor needs to document the diagnosis as they do in any kind of treatment, I don't know why you would need a separate rule for stem cells.
Agreed.
That's what I'm thinking. That's what I'm thinking too. That's one next question too. Yeah.
Agreed, Melanie. And also in this RCW, with Yunling's concern over the consent, it's pretty much outlined as well in this RCW. So I think we have what we need right there.
Okay.
Well,
So is that,
you-
go ahead.
sorry. If we're gonna go for the rule, for the route of making the rule, I still think we should mention it in the documentation to have informed consent process in there. I haven't made up my mind which one is better way to go. Because like Melanie said, I thought about that too. If it's just documentation, we had it already. Informed consent, then we have a law. So only thing is to clarify or make a rule that for 18, 130, 40, 420, it's like. But you have a policy you can't use as a or sanction. You can only recommend shall or must, whatever it is.
Well, I would point out that frequently in our discipline we do refer to policies that we have, and so it's not that you can't use it, but it can't be the sole basis of the discipline, I guess is what I would point out there.
Yeah, an expert can rely on commission policy to form his or her opinion, and that's been upheld.
Exactly. Yep.
Has everybody read the Federation guideline on this? I can send it to you all.
Okay, thanks.
So if you make a rule on make a policy on that, then that would be the place you all think that we can mention RCW 18-130-420. If that's a place that you think better place to mention.
Yenling, I'm not exactly sure why you want us to mention it, but the legislature has. I mean, yes, we can refer people to it in a policy because in a policy that's if they're going to read the policy, they may go and look at this. It's already a requirement, whether they read it or not. It's a requirement. If you don't know the laws of the road, you're still going to get a ticket if you break a law.
Yeah, you're right.
So
I guess what I was saying is about probably not exactly you have to mention whether we have done that before or not, but it's more about informed consent on stem cell, I guess.
that's certainly something that I think we should really work into. If we bring this to policy, which I think we should, we ought to be able to say that the informed consent should contain the following, and that's what a policy does. It's a guideline. It helps good doctors do better.
Right.
Amelia, do we have any other questions from anyone that have not been answered yet?
Let's see. hold on, please. There are some comments. There is one question that says, so what specifically do you hope to achieve that the RCW doesn't cover? It would be helpful to hear even a short list. And then there's another comment that says, I don't know that section 4B is inclusive enough and may inadvertently be choosing winners and losers without adequate investigation of all the potential agencies and those to come. So I guess the only real question there is, what specifically do we hope to achieve that the RCW doesn't cover?
Again, I think that's something that I would like to bring back to the rest of the commission for something like policy committee or something to that effect.
Mm-hmm. Agreed.
So Michael, maybe I ask you a question. In any previous policies, do they mention or mention any language from RCW or specifically explicitly mention RCW as cited in the references?
Yes, they do. When we draft policies and guidelines, we try to provide as much information to the practitioner as possible. So we will mention relevant statutes and rules.
Okay, got it. I guess that the goal is really which route to provide the best message can send out to communicate to practitioners to provide the best practice to protect the public and have the best or the most impact to influence the practice rule or policies. I guess you all probably know more than me on that, especially policy committee. Michael, that you have been working on your lead policy committee.
So is the consensus of the panel then that we request that we rescind the 101, or we recommend rescinding the 101 and doing a policy instead then?
Yep.
That would be my recommendation.
Okay.
Second.
We can certainly do
I
that.
agree.
And we don't have any hands raised, and there are no other questions really to address.
Okay. So thanks everyone for your participation. Amelia will now discuss next steps.
So with the decision to recommend rescission, our next steps have changed a little. We will send that recommendation on to the policy committee at the July meeting. And then, excuse me, they will pass on their recommendation to the full commission at their business meeting, which will be the day after the policy committee meeting. And then we will go from there. So right now it's kind of up in the air what happens.
Thanks, Amelia.
Thanks,
Is
Amelia.
there anyone else who wants to comment before we close? If not, I'll close this workshop and thank you, everyone.
Thank you, Christine.
Thanks, everybody. Thanks, Christine. Nice job.
Okay.
Thank you,
Bye.
Dr. Roberts. Thank you, Dr. Yu.
Thank you.
Thank you, everyone.
Bye.
Bye.